can't stand behind this or you won't see me. So, my discussion today might be contrary to some of the things you've heard, but this has been our experience with this particular case. So we'll just get started. By way of introduction, I'll mention that IFG is an IP company. We're based in Bakersfield, California in the United States, and we're breeders of primarily table grapes and cherries, which we develop, test, then patent in the U.S., and then apply for PBR protection in various countries throughout the world, including South Africa. We then license growers and marketers to plant, harvest, market, and sell our varieties. The case that I'm going to be discussing here is an example of contractual rights and the recognition of judgments that are taken in the United States against an IFG licensed grower of table grapes in South Africa. It's important to note that all of the IFG contracts in this matter state that the governing law, jurisdiction, and venue are designated to be the United States District Court in Central District of California. But all of the activity started in South Africa. During 2014, in an audit of one of our South Africa licensees' plantings, we verified that there were significant discrepancies between the number of plantings for 5 of our commercial varieties, differences in the number of vines that were actually in the ground compared to the number of vines that he should have had based on the numbers of vines distributed from the licensed nursery. We also discovered 277 plants of a variety of ours that had just been released from quarantine in South Africa. By law, it was still in a glass house being subject to heat treatment before it could be sent out for propagation. So no plants of that variety were available anywhere, even in test blocks at the time. And it certainly wasn't available for commercial planting because we didn't have PBR protection. So if nothing commercial was available, how did he get all these vines of a variety that wasn't yet available in that country? We asked the licensee that very question. He actually was a personal friend for a long time of one of the founders of IFG. But we asked him, how did he get all of those vines of our experimental variety? He stole it. He told us jokingly that he probably shouldn't be telling us this, but the previous summer when he was in California, he had stolen a shoot from one of the IFG test blocks. He made sure that he took it from a bearing vine so that he would get the variety that he was after. Then he put it in a suitcase and smuggled it into South Africa, bypassing the quarantine. So then there were 5 buds on the shoot. He took those and began doing green grafting, and that's how he was able to create so many vines. So it turned out that he had not only stolen an experimental variety, but he propagated it without authorization, and that was against IFG's policies and his contracts. So we began immediately to look into the matter and have meetings and discussions with him. And as we did, we discovered that the list of his infringements included not only the propagation of thousands of vines without authorization and in violation of his contracts, but also propagating the material to another IFG licensee and an unlicensed nursery in another country without a propagating license, selling IFG material to a third party, and further charging them a supply fee and a royalty on the IFG plants, which he had no right to do. Packaging, selling, and exporting IFG varieties under other labels and without proper paperwork, as well as the stolen shoot that was illegally taken into South Africa. Things actually happened very quickly as soon as this was discovered and verified. We discovered the plants. We had the meeting with the infringer on his farm, where he admitted to stealing the vine. That same month, we obtained DNA on the fruit, on the plants. It was a definitive match to our variety. On May 9th, our counsel sent a letter to the infringer, letting him know that his actions were violations not only of the IFG contracts that he was a party to, but also PBR law and potentially criminal laws in South Africa and California. On May 19th, we met in Bakersfield with the infringer and tried to settle the situation so that we could remedy the infringements. He would have to destroy the vines and notify the South Africa Department of Agriculture what he had done. We informed him that we were entitled to and would declare an event of default if he did not rectify the situation and destroy the plants. We would also notify the South Africa Department of Agriculture so that we would avoid any complicity in his illegal actions. And no further plants would be distributed to him until the matter was cleared up. The infringer did agree to destroy the illegal plants, but he refused to notify the South African authorities when he returned to South Africa. Therefore, on May 29th, IFG sent a letter to DAF to avoid complicity by our part in the illegal action and to clarify what the situation was. On June 11th, we notified the infringer that his test agreement was being terminated for events of default and that he must cease use of all proprietary varieties, destroy all IFG vines. Thereafter, we also canceled his planting rights and marketing rights contracts. So we had offered the infringer the opportunity to remedy the situation. Instead, on June 24th, 2014, the infringer filed against IFG an urgent application in the High Court of South Africa. South Africa rules of court for normal proceedings allow for a certain amount of notice requirements so that a responding party will have time to answer any affidavit. But there are special situations in which time is considered to be a critical factor, which may result in grave prejudice or harm to a party if it's not acted on immediately. So by filing an urgent application, an applicant is asking the court to waive the normal notice and give preference to the applicant in order to prevent the harm that's claimed. In this case, by filing an urgent application, the infringer was attempting to bypass notice to IFG, because the courts generally do not recognize commercial urgency as a basis for this type of filing. Here, IFG caught a break. The advocate that originally filed the urgent application, intending on giving no notice, was assigned to another case at the time, and the advocate who was then assigned to this case felt compelled to advise IFG of the matter, and therefore this was a 100-page affidavit was served on IFG in California, providing for a hearing to be held early the next afternoon. Fortunately, we had our solicitors here in South Africa already engaged. We were able to contact them, and upon his request to the court, we were granted an extension of 1 week in order to answer to the infringer's claims. He claimed that the contract was not legally or validly terminated by IFG, as well as numerous other demands and claims for damages. Our position during this was very simple, although we expressed it in 100 pages of response to the infringer's application. We stated that South Africa had no jurisdiction in this matter. On the basis of the contract terms, the U.S. District Court had concurrent jurisdiction and any disputes arising from the agreements, and also had ultimate determination resting with the California court. The infringer was also asking for a final ruling which would impair IFG's rights and make it impossible for IFG to recover damages in the event the California ruled in its favor, likely 1 or 2 years down the road. I would like to point out at this point that the fact that we were able to respond in 4.5 days, 4.5 working days to this size of an action was entirely due to the fact that we had good counsel engaged, and they just did a fabulous job working with the IFG team on a really short notice and a very diligent effort in order to be able to accomplish this. We petitioned the court to decline the exercise of jurisdiction over this matter and deny the infringer's requests. On July 23rd, 2014, the South African High Court agreed and dismissed the infringer's application. So our contractual requirement that the matter be heard in California won that ruling, but it was thanks to the excellent action by our attorneys and the IFG response. We then moved to California. In August of 2014, IFG filed a complaint in the U.S. District Court reciting the known and admitted actions of the infringer in violation of the valid IFG contracts between the parties. In addition to his prior claims, the infringer claimed in his defense, in defense of his behavior, that his illegal actions were not sufficiently significant to warrant cancellation of his contracts. Throughout these proceedings and those that followed, he continued to try to cause maximum interference and inconvenience to IFG by attaching claims and damages and throwing in untrue and unrelated issues. Again, IFG's position was very, very simple throughout this, although we did have to address all of the infringer's numerous claims throughout and whenever they occurred. But we stated that in addition to violating national and international laws, the infringer had committed multiple events of default by illegal propagation, and therefore, pursuant to the terms of the contracts, IFG was justified in canceling the contracts. And according to the contracts, IFG's rights under an event of default were that we could terminate the contracts, and the infringer would have to remove and destroy all IFG vines by cutting beneath the graft. On December 10th, 2015, the infringer and IFG each filed motions for summary judgment in California. Those are common filings, but they're rarely successful. On April 20th, 2016, the California District Court denied the infringer's motion and granted IFG's motion for a summary judgment and entered a judgment for a permanent injunction requiring the infringer to remove within 20 days all IFG material in his possession by cutting the vines below the graft. Granting a summary judgment, as I mentioned, is a very rare achievement, but in our case, our case was considered very strong. The court said the defendants, referring to the infringer here, are attempting to apply general California contract principles to the present case, disregarding the express terms of the contract. The agreements clearly set forth the specific grounds on which IFG may terminate the contract. When a contract has a termination clause, the clause controls, and a party to the contract may terminate only in accordance with the terms specified. Since the parties expressly address the events of default that would lead to termination, the court must assess the conduct of the parties according to the agreement. In September 2016, there was an article in the South African newspaper called "Sour Grapes Over Stolen Shoots." This was negative publicity throughout this article of the infringer's actions and was also a public announcement of IFG's stance on the infringement of its IP. So with all of the wins coming on our side and 2 appeals in California still waiting for the infringer, IFG made a settlement offer to the infringer in October of 2016. He would be required to cut the vines below the graft. This was never a negotiable item on our part, but he would pay a reduced amount of attorney's fees. He accepted that settlement offer by email in December of 2016, but the next month it was off the table. So with the win in California, it should be over anyway, right? Nope. Start the appeals. So over the next year and a half, The infringer filed numerous motions to try to evade the judgment. We were required to answer every time he filed. Each of the infringer's papers was ultimately denied, making the California judgment fully enforceable. By June 2018, 3.5 years after it started, the infringer had filed and lost all of his appeals in California. IFG had filed and also won 2 additional cases in California against the infringer's 2 related companies that also had IFG contracts. IFG then petitioned the High Court of South Africa to enter orders enforcing the California judgments, which it did. During this time, IFG also petitioned for and was awarded attorney's fees in excess of $600,000, and this was later increased because of the expenses incurred during the appeals. Meanwhile, back in South Africa, with the orders in hand and with the local sheriff present, IFG began audits of fields to ensure the destruction of the vines below the graft. They made multiple trips and found that many, if not most, of the vines were cut above the graft, and the IFG plants were regrowing in numerous instances. We had to document this and make additional demands for compliance with the order. We are to this day dealing with the issue of how the vines were cut and what is our risk of future infringement because of this. The situation for the infringer is that he has used up all of his avenues of appeal. And if he does not comply, we can bring contempt proceedings, which could result in jail time for noncompliance. So throughout this 5-year saga, we've had multiple urgent applications, all of which must be responded to in a timely and thorough manner. Multiple letters to the judge advising of inappropriate actions on the part of the infringer's attorneys, perjury by the infringer, which is a criminal offense in the U.S., punishable by up to 5 years in prison, proceedings for damages, as well as numerous trips with the sheriff to the infringer's farms to try to investigate the removal of the plants. 3 factors worked heavily in our favor for obtaining the universally positive results in this case to date. One was a highly qualified and dedicated team, primarily our international business manager, who continues to spearhead our efforts, keeps excellent notes, and somehow has kept her sanity throughout this time-consuming and frustratingly slow process. 2 is a qualified and engaged legal teams that understood our program and issues and fought for our IP rights. And 3 was contracts that contain clear terms and conditions setting forth the rights and responsibilities of the parties. We learned from this experience that to have the best chance for successful defense, don't act hastily, but do act swiftly when infringement is discovered. Make notes of all events surrounding the action so that you can rely on those notes when accusations and claims are put forth over the coming months and years of an action. Your defense should start well before the infringement takes place. It starts with your contracts. Establish a strong foundation for your defense with strong contract language and unrelenting adherence to the contract protocols. The contracts should be detailed and specific. They should define not only what constitutes an event of default, but also what your rights are upon an event of default. If a proposed licensee doesn't want to sign a detailed agreement, then it's likely that's not a licensee you want to have. You need to make the vetting of your licensees a requirement to ensure that you're not granting a license to someone with a history of infringement. You don't know where the infringement's going to come from. It could be a friend. And when the legal action is required, make the needed personnel and documentation available to your legal counsel as needed, realizing that it will be a time-consuming event. So what did we accomplish? IFG spent over $1 million in defense, plus hundreds of man-hours from depositions of our officers and employees and key person document preparation, monitoring and responding to attorneys representing multiple actions on 2 continents, as well as repeated visits to the infringer's farms to measure compliance on the one thing that mattered most to us, destruction of the infringer's vines in a manner that would prohibit future use of our material. The consequences to the infringer were more costly. More than $1 million awarded to IFG in damages, which he hasn't paid. More than $1 million in his own legal costs. destruction of over 130,000 vines, and damage to his grower reputation. Does an action like this set an example? Yes, it does. And as luck would have it, there's going to be another article in the paper here. In fact, in the South Africa Times Select, there'll be an article tomorrow on this very case. So was it worth it? For IFG, at the end of the day, we're an IP company, and we believe protection of our IP is vital, not only to our company, but to our licensees as well. If you don't take a stand and demonstrate to your licensees that you're going to defend the unique nature of your IP, then your value to them is diminished, and your vulnerability for future infringement increases. But without strong contracts, your ability to defend your IP will be compromised. As closing admonition with regard to contractual enforcement was summed up actually very well by the California District Court and by its ruling in our favor on the summary judgment. It said, where contract language is clear and explicit and does not lead to absurd results, we ascertain intent from the written terms and go no further.